So, what is the status of the right to free speech in India? So, right to freedom of speech and expression is a constitutionally protected right. It's protected by Article 19 of the Indian Constitution. We need to spend some time on the language of Article 19 and the reasonable restrictions that are imposed on the exercise of right to freedom of speech and expression. Um, Going back to the Constituent Assembly debates, Article 19 then formed the draft Article 13 of the Constitution. And while the protection being granted to the right to freedom of speech and expression was not the issue of debate, the Constituent Assembly debated the nature of restrictions imposed on the right to a great deal. So, the formulation of Article 19 is such that in Clause 1, there are different kinds of freedoms that are guaranteed. Article 19, Clause 1A guarantees the right to freedom of speech and expression. Um, Clause 2 of the same article imposes restrictions on the exercise of the same right, which are guaranteed in Clause 1. So, the nature of restriction that was debated since the Constituent Assembly to the present time has changed. We need to go over that trajectory and understand how the change has happened. Let's go back to the Constituent Assembly debates, and I'll read out a particular section, which was the draft Article 13 then. The then draft Article 13 said that though the right to freedom of speech and expression was guaranteed, it was not to affect the operation of any existing law or prevent the state from making any law relating to number one, libel, number two, slander, number three, defamation, number four, sedition, and number five, other matters that would offend the decency or morality of the state, number six, or undermine the authority or foundation of the state. So, according to the draft Article 13 of the Indian Constitution, there were six restrictions imposed on the exercise of right to freedom of speech and expression. In the name of all these six, the state had the right to make laws and impose restriction on the exercise of freedom of speech and expression through these laws. The final section that was inserted in the Constitution underwent a few changes, and finally, what was accepted was this in 1949, which was finally adopted in 1950. It said nothing shall affect the operation of any existing law insofar as it relates to or prevent the state from making any law relating to, again, number one, libel, number two, slander, number three, defamation, number four, contempt of court, a new edition which was not in the original draft. Number five, offense, anything that offends decency or morality. And number six, or which undermines the security or tends to overthrow the state. So, six restrictions were finally adopted as constitutional restrictions on the exercise of freedom of speech and expression. Contempt of court was added, and sedition as a restriction was removed. Sedition is a law that penalizes forms of expressions that attempt to incite disaffection against the government and attempt to incite any kind of contempt, hatred, or feeling of enmity against the government. This law has been qualified by the Supreme Court in 1962, and after the qualification by the Supreme Court, just inciting these feelings would not constitute sedition, but through the incitement of these feelings, one should tend to incite disorder or unlawful tendency in people against the government. But we'll come to that a little later. So the final draft of the Constitution mentioned these six as restrictions and did not use the word reasonable. It only mentioned restriction. The word reasonable was added a little later in 1951 through the First Amendment to the Indian Constitution. Before we come to the First Amendment, let's look at what the final article today stands. I have the Constitution in my hand and I'm reading out from the Constitution the provision on restriction on freedom of speech and expression. So it says, nothing shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of number one, sovereignty and integrity of India. This was actually introduced through the 16th Amendment in 1963. Number two, security of state, which was there even in the original constitution. Number three, friendly relations with foreign states, which was again introduced in 1951. Number four, public order, which was also introduced in 1951 through the First Amendment. Number five, decency or morality, which was there in the original constitution. Number six, in relation to contempt of court, which was also there in the original constitution. Number seven, defamation, which was also there in the original constitution. And number eight, incitement to an offense. So there are altogether 8 kinds of reasonable restrictions on the exercise of right to freedom of speech and expression. So if we've understood the relationship between Article 19, Clause 1 and Clause 2, it means that Clause 1 guarantees you the rights, Clause 2 takes away those rights in order to protect these 8. In order to prevent the state, in order to make the state protect these 8, it can impose any limitation on the exercise of freedom of speech and expression. Let's see what are the kinds of laws or offenses that allow state to impose restrictions on the freedom of speech and expression. I have the Indian Penal Code in my hand. And we'll try and go through some of the categories of offenses and the related laws that restrict freedom of speech and expression. Largely, one could say that expressions are limited through different kinds of laws. And these are laws that try to penalize specific kinds of offenses. So you have political offenses related to speech, like sedition, and you have the law of sedition that penalizes seditious expression, that penalizes political speech. You have social offenses like hate speech, and you have laws against hate speech that penalize promotion of hate speech. You have individual offenses against individual, speech-related offenses against individual, like defamation. So if you harm the reputation of someone, that person has the right to file a defamation case against you. Defamation is both a civil and a criminal law in India, which means that the court can also convict you, sentence you for having committed defamation. The court can also impose a fine on you for having committed defamation, जिसको कहते हैं मानहानि का दावा ठोकना. So offenses are of different kinds. They're individual in nature, they're social in nature, they're political in nature, and through this plethora of restrictions that Article 19, Clause 2 provides for, all of these kinds of offenses can be catered to or penalized through different laws. I just want to briefly talk about what are these different kinds of laws and just very, very briefly take you through the legal provisions. So Section 124A of the Indian Penal Code. As we all are aware, the Indian Penal Code is the collection of, it's the How do I put it simply? It basically contains all kinds of offenses within the jurisdiction of India, and how these offenses have been defined in legal terminology, and what is the punishment that these offenses entail. All of these things are contained in the Indian Penal Code. Now, the first category, which is political offense, Section 124A of the Indian Penal Code, which is the law against sedition, penalizes political speech in the name of sedition. It says disaffection against the government is not protected as a free speech right. So you do not have the right to spread disaffection against the government. Government के खिलाफ असंतोष की भावना नहीं फैला सकते in the name of exercising your freedom of speech. Section 153A of the Indian Penal Code. This is the provision related to hate speech. What does it say? Promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to maintenance of harmony. So, promotion of enmity. If you spread enmity between different groups through words, through any form of visible expression, then you are a guilty party under Section 153A of the Indian Penal Code. In social terminology, this would be called the offense of hate speech. Section 292 and 293 of IPC related to obscenity. It bans sale of obscene books, sale, etc., of obscene objects to young persons. Laws related to pornography. How has obscenity been defined in Indian law? So it has been defined as anything that appeals to the prurient interest of the individuals or of human beings in general. Anything that incites prurient interest in people is considered to be obscene. Hence, an offense against the morality and decency of the society. Morality and decency has been defined as a reasonable restriction under Article 19, Clause 2. Section 295A of Indian Penal Code, this is related to the offense of blasphemy. We don't have the usage of the word blasphemy in India as was the case in England, but we have something equivalent to blasphemy, which is offense against religion. What does it say? Deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion or religious beliefs. So, insult to religion through deliberate acts is the offense against religion. It's the offense of blasphemy. Coming finally to offense against the individual, Section 499 of IPC, which is the law against defamation. How has defamation been defined in the Indian Penal Code? Harm to the reputation of any person. Now, if we closely look at the language of these offenses or the laws that penalize these offenses, most of them talk in the language of insult, harm, offense. Contempt of court is something that is not there in the Indian Penal Code, and you have a Contempt of Court Act. It was passed in 1971. And one part of contempt of court is use of scandalous, anything that scandalizes the people towards the court or lowers the reputation of the judiciary in the eyes of the people is considered to be an offense of contempt of court. Now, if we closely look at the language of these laws, they are mostly talking about how speech can be offensive to someone. Defamation, for example, does not use the language of offense, it uses the language of harm. But harm is not described in an objective sense. Harm is also described in a subjective sense, harm to reputation. This is an important debate in the legal framework. There's something called the harm jurisprudence and something called the offense jurisprudence. Legal philosophy has tried to distinguish between the two, between offense and harm. Offense is a more subjective feeling, it's a more subjective criteria. You may be offended by a lot of things that may subjectively impact you. But everything that you find offensive does not necessarily harm you. Harm, on the other hand, has been defined more as an objective category. Um, Even if we go back to people like James Mill, they would have they actually J.S. Mill or Ronald Dworkin, they did define what harm is, and their sense of harm was a direct attack or a direct violation of a particular right that has been guaranteed to the person. So if your right has been taken away from you, you've been stripped of a right that was guaranteed to you, then it would be considered to be an objective harm. Otherwise, everything else remains in the subjective domain of offense. Now, the manner in which Indian laws restricting speech have been defined, they mostly take form of offense jurisprudence. Most laws do not talk about what is the nature of direct harm that the person would suffer if that person is subjected to an injurious speech or an extreme speech. For instance, blasphemy or contempt of court. So, if the judiciary is subjected to a form of expression that lowers its reputation in the eyes of the people, what kind of harm would the judiciary suffer? Is there really an objective sense of harm that the court undergoes through contemptuous uh, incitement, through contemptuous expression against it, or say offense to religion, blasphemy, so outraging religious feelings of a person or a community? What is the nature of harm that the person who's outraged through a certain expression against his or her religion suffers? That's something that Indian laws do not dwell upon. Actually, the only kind of law that talks about the real harm that any person would suffer is related to hate speech, but and it's also because of the dynamism involved between communities. So hate speech is not about speech of one community against the other who are all on the same level. It's about uh, targeting people of a different community who may not be at the same pedestal, and which is where hate speech actually takes form of a harmful speech. um, in US, for instance, racist speech, the speech that white supremacist groups use against the blacks in America, would take form of that kind of injurious or harmful speech. In India, we lack that kind of nuanced understanding. In India, what we have is what I just read out to you. How has the judiciary dealt with this? How has the judiciary looked at the question of harm versus offense, looked at the question of threshold as we were discussing through the debate between Austin and Butler? So, how has the judiciary been able to devise those parameters, devise those norms that the legal framework should follow in order to restrict freedom of speech and expression? And for that, we need to go through the judicial discourse on freedom of speech and expression. But any discussion on the free speech jurisprudence would be incomplete without taking into account the American free speech jurisprudence, not because it's America, but because the American free speech jurisprudence, by and large, would be considered to be the most robust free speech jurisprudence, which has evolved criteria after criteria in order to grant the most enhanced kind of protection to extreme speech. The debate on freedom of speech and expression is important only as long as we are debating the extreme speech, because all those kinds of speech that are non-controversial, that are not considered to be injurious, not considered to be harmful, are in any case protected, and nobody would need to debate the right versus restriction framework in relation to those forms. It's the Voltairean idea, uh, the Voltairean defense of free speech, which would say that I disagree with you, but I will defend your right to speak till death or whatever. That's the kind of Voltairean defense of free speech. The American court seems to have taken, to a large extent, even though in America it's not an absolute right, but to a large extent it has taken a very enhanced kind of protection towards free speech. And there are two to three free speech norms evolved by the US Supreme Court that we need to discuss before we move to the Indian judicial discourse. Um, United States of America until 19 until the early 1900s followed something called a bad tendency test to restrict freedom of speech and expression. So any speech which was believed to have a bad tendency was not to be tolerated, was not to be protected. What is a bad tendency? Any speech which is likely to result in any harmful uh, consequence. So anything that is abusive, any ill will feeling is likely to produce, is likely to tend towards a harmful effect. So anything having a bad tendency was not to be protected. It was only in 1919, and again by Justice Holmes, who gave the market's place defense of free speech, while giving his note of dissent in one of the judgments, Shenik versus State, in 1919, he evolved a free speech norm called clear and present danger test. What was the clear and present danger test? He said any speech that has a bad tendency does not need to be restricted. Why? Because a lot of things have a bad tendency. They can result in something bad, but they do not necessarily result in something bad. The potential and the actuality of speech resulting in something bad needs to be separated from one another. And according to him, the clear and present danger was that separation. What did it mean? He used a particular example, which was the false cry of fire in a theater. So, if you are in a theater, you're in a confined space with a lot of people. If you deliberately make a false cry of fire, then this is going to pose a clear and present danger. Why? Because it's a situation in which the bad effect of the speech is too proximate to the speech. The bad effect is most likely to take place. It's not in the realm of mere possibilities. The possibility is too direct, too immediate. So it poses a clear and present danger. Justice Holmes said that in order to separate any bad tendency speech from those speech that pose a more direct threat, you need to employ this criteria called clear and present danger. It would help you separate those speech that may lead to something bad, but the possibility of them leading to something bad is almost non present or very marginal. In that case, you need to protect. For instance, if someone cries fire falsely in an open area where people could ignore what he said, or people could simply evade that space without having to create a panic which would necessarily lead to a certain amount of harm, would be a protected form of speech, even though it's false. But in a theater, in a confined space, that speech should not be protected. It is liable for punishment. This was the clear and present danger test. The clear and present danger test was improved upon. There were other additions added, especially in the um, through the trial of communists in the um, uh, interim war period, the interim period between the two world wars, and in the starting years of Cold War, through the trial of the communist and the trial of members of the Communist Party of United States of America, many free speech norms were evolved. Some were progressive, some were regressive. Some tried to enhance the free speech. Some tried to enhance the protection granted by clear and present danger test. Some actually took away that particular protection also. But it was finally in 1969, through the Brandenburg versus Oyo test, is a case, that the final free speech test was laid down by the US Supreme Court. This free speech test was called the Imminent Lawless Action Test. What was the Imminent Lawless Action Test? It said that for any speech to be restricted, it must meet three requirements. First, the speech should clearly incite people. There should be express incitement in the speech. So, anything that is confusing, which does not give clear instructions to people, something that has been said metaphorically without clear incitement, will not meet the first criteria. So, there has to be a express incitement to violence or to any unlawful action in speech. Second, the incitement would be of an immediate character. So if you are inciting people to violence or towards any unlawful conduct, suppose you're inciting people to not follow a certain law, to not obey a certain law, there has to be a direct incitement, number one. And number two, it should be of an immediate character. It shouldn't be about a situation that's going to happen 10 years after or 10 days after also, because the logic is that if you are forbidding someone from speaking because that person's speech is likely to create an action, then there has to be an immediacy to the situation. Suppose I'm saying something that you're hearing and you decide to act on it 10 days after, then the liability shouldn't be mine. You've thought enough about it, you've spent days and nights thinking about it, processed it. It's through your rational decision that you're going to be acting on it. It's very different from a riot like situation, or talking to an incited mob, talking to a lynch mob. Where people are incited, it's a condition of diminished rationality. This is what Thomas Canlin talks about. These are situations of diminished rationality, riot, lynching, where people are unable to think. And in that situation, insightful speech should be taken out, which is why leaders are not allowed to address the public in a riot like situation, because it's a palpable situation, it's a tense situation. So the incitement, according to the second criteria, has to be of an immediate character. It should be direct, it should be of an immediate character. And third, it should be likely to occur. So if I'm inciting someone to go behead someone, the possibility of that person being able to behead that person should also exist. Suppose I'm talking to a person who has no whereabouts to go give effect to that particular action, then even if the person gets incited through my speech, the speech will not result in an action because the person is incapable of performing that action. So there should be a likelihood to the situation. So three things: direct incitement, immediate incitement, and third, the likelihood of incitement to result into an action. It is believed that after the Brandenburg test, after these three criteria that form the test of imminent lawless action, the US Supreme Court is believed to have tied its own hand, tied the hands of the government so much that it's almost impossible for any free speech prosecution to be successful. And for many years, one has seen a certain kind of enhanced protection until the 2000s with the introduction of new terror related legislations which have provisions related to free speech, and they have had a chilling effect on free speech. And in the name of quote unquote terror inciting speech, a terrorist speech, there's a certain dilution of standards that even courts uh, accept. Why? Because terror is believed to be a more imminent threat, and a lot of times the safeguards and protection that is extended to people in ordinary crimes are not extended to people charged or accused of terror crimes. Now, that's also a limitation on the free speech jurisprudence that we must be aware of. But for now, we'll leave that for another discussion. Coming back to India, how does India adapt the US free speech jurisprudence norms? And India does adapt to a large extent, but it's only in the 2015 with the Shreya Singhal judgment that we said to have adapted it completely, not before that. Now, in India, the free speech discourse begins to shape with the First Amendment. And the First Amendment in 1951, which led to the introduction of the word reasonable, affixed to restriction, and also introduced two more kinds of restrictions in Article 19, Clause 2, was actually prodded by two particular judgments, both Supreme Court judgments. The Brijbhushan versus State of Delhi and Ramesh Thapar versus State of Madras. These were two cases in which the publications, one an RSS publication and other a left publication, Crossroad in Madras. Both of these were forfeited under the Public Safety Acts of the respective states. And the publishers of both of these publications approached the Supreme Court saying that this is violation of their fundamental right to freedom of speech and expression, because the Public Safety Acts or the Public Order Acts cannot impose restriction on freedom of speech and expression, because public order was not a reasonable restriction. It was not a restriction on the exercise of Article 19. You could restrict freedom of speech and expression in the name of security of the state, but not public order, because it was not written in the Constitution. And the Supreme Court upheld both the petitions and asked the government to take back the restrictions imposed on the publications. This prodded the Nehru government to amend the constitution. Public order as a word was added to reasonable restriction. The word reasonable was also added, and the word reasonable had a certain character to it. Reasonable was a legal term. What did it mean? It meant that from now on, when the courts are assessing whether a restriction imposed on the right to freedom of speech and expression of an individual by the government is justified or not, the courts can look at the reasonability quotient of the restriction. And reasonability was a word that was to be defined by the courts variously. And the courts have used different parameters to define the word reasonability. Proportionality is one such test. The arbitrariness is another such test. For example, the court would try and see whether uh, if a law imposes restriction on my right to speak, is the harm done to me because my right is restricted greater, or the harm that my speech would do to the society if I'm allowed to speak is greater? Which is a greater harm? If my harm is more, and if I'm being allowed to speak, the society does not suffer really much, then the law becomes unreasonable. It's not reasonable because you're not balancing the restriction on the right versus the harm that the right is likely to produce. So these are different criteria through which the word reasonability is defined. And the courts have used this particular empowerment to define reasonability, to decide in time and again whether a particular law is reasonable or not. For example, in 2015, when Section 66A of the IT Act was struck off, it was struck off because it was believed to be an unreasonable provision. So while the IT Act is still there, Information Technology Act is still there, one particular provision of the Act has been declared unconstitutional and struck down. Why? Because it was unreasonable. It was overbroad in its provision. It was too vague that it could impose unreasonable restrictions on the exercise of right to freedom of speech and expression. So in 1951, with the First Amendment, now public order became a reasonable restriction. And from there on, one sees that in the name of public order, governments had greater power. Subsequent governments, successive governments had greater power to impose restriction. Why? Because it was very easy to prove that any speech related offense is harmful to public disorder. So, all of these offenses from the Indian Penal Code that I read out to you, whether it's offense against religion, insult to religion, hate speech, etc., could very easily be proved to be offenses against public order, as opposed to security of state, which is a larger term. Not everything threatens the security of the state, but most things are likely to be perceived as threat to public disorder. Why? Because public disorder has been defined very, very vaguely. Public order has been defined very vaguely. Public order has been defined as a state of public tranquility, where people are at peace and feel safe. Any act that substantially threatens a significant amount of people and takes away their sense of security, sense of safety, or destabilizes them becomes a threat to public order. So, hate speech very easily becomes a threat to public order. Offense against religion. If people are incited because their religion has been accused, their religion has been insulted, it's very likely to it's a very likely situation that's going to provoke public disorder. Why? Because people would, be up in anger, be out on street, would have been provoked to a certain reaction, would want to harm the person who's um, tried to harm their religion, etc. So with the insertion of public order, all of these laws were given greater powers to restrict freedom of speech and expression. What has the court done? What has the Supreme Court done in order to then carve out a threshold which would try to restrict the powers of these laws and not allow them to arbitrarily use public order as a word, as a reasonable restriction to restrict any form of speech. And for that, we need to go through a series of orders, a series of judgments. The first being Ramjilal Modi in 1957. Ramjilal Modi was a case in which Section 295A of the IPC, which is provision related to insult to religion, was on trial. So the person had been accused of offending someone's religion. The court introduced, now we're trying to do the same thing like we did in America, look at the free speech tests like clear and present danger, imminent lawless action, how Indian courts have devised similar tests or have failed to devise similar tests. So in Ramji Lal Modi, the court introduced something called the calculated tendency test, which was different from the bad tendency test. So like I said, bad tendency is any tendency which is likely to effect a harmful consequence. Calculated tendency is deliberate in nature. So I may have done something that may have offended someone's religion. It can be a bad tendency speech because, so those cartoons. So if I have drawn, if I've made a cartoon which is likely to offend someone, it's a bad tendency cartoon because it is likely to offend people. But was my intention to do the same? No. If my intention was just to give expression to my thoughts, then it's not a calculated tendency. It may be a bad tendency, but not a calculated tendency. There was no deliberate attempt on my part to offend someone, insult someone's religion. So this calculated tendency test was introduced by Ramjilal Modi. But in US, where you see a linear movement, one free speech test is replaced by another free speech test which grants enhanced protection. Unlike that, in India we have a crisscross. So you have one free speech test enhancing protection to speech, and then you have another test which takes away the protection. So in 1962, in a case of sedition in Kedarnath Singh versus State of Bihar, bad tendency test was restored and calculated tendency was thrown out of the window. How? Because the tendency, Kedarnath test said that any speech which tends to disorder or tends to violence will be seditious, should not be protected. Which means that you've taken away the aspect of calculation involved, and you've said any speech which is tending to violence, whether or not the person deliberately wanted to do that, is not to be protected under right to freedom of speech and expression. So from 1962 in Kedarnath Singh, you then move to Rangarajan in 1989. And Rangarajan Test in 1989 was really an improvement upon how the free speech jurisprudence in India has adapted the American standards. Uh, Rangarajan case was about about restriction, censorship imposed on a film, a South Indian film. And in this particular test, the Supreme Court adapted almost something like the clear and present danger criteria that Justice Holmes had talked about. The Supreme Court in India introduced the analogy of spark in the powder keg. Uh, Powder keg, so I'm sure we've all heard of gunpowder. The spark in the powder keg was about that particular situation in which if you see a spark near a packet of a gunpowder, fire is certain, an explosion is certain. But if you have a spark in a context where there is nothing explosive around, then even though the spark remains the same, it's the same spark. But because of the absence of anything explosive in the vicinity, the spark dilutes or diffuses its harmful effects. So the Rangarajan test, through the spark in the powder analogy, introduced this aspect of clear and present danger. कि अगर कोई पैल्पेबल सिचुएशन है, जैसे गन पाउडर का बोड़ा रखा है और वहां पे आप कुछ स्पार्क करो, तो ऐसी स्पीच से नुकसान तय है. That speech is most certainly going to result in a harmful consequence, and that kind of speech cannot be protected. But any speech which has sparks in it, which may be explosive, but there is nothing explosive around it to catch fire, then why do you want to penalize that kind of speech? Now, this means that the content of the speech remains the same in two situations. But in one situation, it can be protected because the context is not felicitous, bringing Butler back. The context is not appropriate for fire to be caught. But in another situation, the same speech cannot be protected. The content remains the same, but in this case, the speech cannot be protected because the context is tensed. It's palpable. You cannot allow the person to speak because it's going to catch fire. The Rangarajan test has not really been adapted as a doctrinal standard in all the free speech, in all the extreme speech cases. There are largely very few cases that refer to the Rangarajan test. In India, we also have a peculiar judicial trend in which it's the provision, it's the law, and the judgment on that particular law that creates the idea of the precedent. So if Kedarnath Singh was a sedition case, then for all sedition related cases, one would go back to Kedarnath Singh. Although that's not how precedents work. Rangarajan Test, spark in the powder keg, could very well be used to adjudicate all cases of 124A, all cases of sedition, all trials of sedition. But you have very few times the courts referring to the Rangarajan case in a trial of 124A. Unlike the Western jurisprudence, where um, provision specific norms are not evolved, norms are evolved as universal in general, which apply to all laws related to speech, not specific provisions related to penalizing speech. Finally, in 2015, which was the same case which declared Section 66A of the IT Act unconstitutional, this was the Shreya Singhal case in 2015, that India adopted the Brandenburg Standards, the Supreme Court in India, in which the Supreme Court said that incitement to an offense will not be, incitement to violence will not be a crime. Advocacy to violence will not be a crime, only incitement to violence will be a crime. So there's a difference that the court makes between advocacy and incitement following the Brandenburg Standard. What was the Brandenburg Standard? Incitement has to be direct, immediate, and likely. Advocacy, on the other hand, is just a general preference. So if I'm taking sides, I'm advocating something. So I may advocate unlawful activity, I may advocate violence, but it just means that I'm expressing myself, my personal opinion. I'm advocating it. I am not making someone perform it, because that will happen through incitement. And that's the nuanced distinction between advocacy and incitement. Advocacy का मतलब होगा हिमायती, किसी की हिमायत करना. Incitement, uksana. So there's a difference between taking side and provoking someone to do something, inciting. And that has been adapted as a standard in 2015 by the US Supreme Court, finally. Um, we have laws such as UAPA, Unlawful Activities Prevention Act, and other such laws, even sedition, for instance, following the Supreme Court reading down of the provision as well, which do not make that distinction between advocacy and incitement. So, currently, we are in a situation in India wherein the judicial doctrinal standard exists, but the laws that are being made do not approximate to the doctrinal standard, and the constitutionality test that these laws should undergo in order to approximate to the doctrinal standard, the impetus for that moment to subject these laws to constitutionality test is also missing. And if the courts have been approached to reconsider, for instance, the law of sedition, where PILs have been filed in Supreme Court to reconsider the ambit of criminality of these laws. In such cases, the courts have been unwilling, the Supreme Court has been unwilling to reconsider the ambit of criminality. So while you have the judicial protection through doctrinal standard, after Shreya Singhal, after the difference between advocacy and incitement, it is not something that is meeting the ground. So on ground, you have a much decreased protection, truncated protection to the free speech right in India. That's all.